The first aspect relates to the number of seats that can be contested by independents. You will recall that the challenge was that the current 200 seats that are available for independent candidates was insufficient, and that they wanted the numbers to be increased to 350, so that the political parties are reserved only for 50, because the Constitution requires that we have only 400 seats, or not more than 400 seats in the National Assembly. Now, the argument was that if you have 200 to 200 split, it is actually justifiable, because it will not lead to what we call excessive seats, or what is normally referred to as overhang. Overhang basically means that you have got more people qualifying to be in parliament than the number of seats available. So what do you do with those individuals? And then therefore, apparently, according to the study that was given by Atkins, it indicated that in the 200, the risk is very less. And when it comes to the 350 to 50 split, that there was a very high possibility that we will have that situation of excessive seats or overhang. The second aspect, therefore, deals with the requirements for an independent candidate and new parties to participate in the process. That requirement, in terms of the Electoral Amendment Act, was that 15% quota would have been required, which is 15% of what it would have required for a party to get a seat in the last election. Now, that obviously was now put in the requirements of signatures, the number of signatures between 10,000 and to 15,000. Now, with this judgment, it means the requirement now is only 1,000 signatures of registered voters, which really it's a significant relief for those who will be contesting the election as independents. But I think it is not going to cause major havoc for the Electoral Commission, because there are other mechanisms that the Commission uses to make sure that you do not have frivolous participants in the process. There is still a deposit that is required to contest an election. I think this fairly represents a very balanced arrangement for people to participate in the elections as independents or new political parties even.
All right, Terry, thank you for that. That, in fact, was going to be my follow-up question, just in terms of vetting and the quality of independent candidates following that judgment by ConCourt. So as we edge closer to elections, perhaps you could speak to the importance of this judgment, IC preparations as well.
Yeah, the judgment is important, particularly because the independents will be participating for the first time in these elections. And remember that the majority of independents do not have the infrastructure nor the financial resources that the major political parties have. So it is significant in that instance that the requirement has been lessened to make sure that those who are really willing to participate can participate, being able to garner sufficient signatures to be able to participate in the process. For the Electoral Commission, I think the fear was that if the quota was actually changed the way it has been changed, you will have now a flood of frivolous participants in the electoral process. But I think because there's another mechanism that has already been put in place, which is that of the deposit that will be required, it is unlikely that we will have a flood of independent candidates participating. But at the same time, it entrenches the rights of individuals to contest for the elections as contained within Section 19 of the Constitution.
Terry, some concerns about the delay regarding this judgment. Some of the view that it was jeopardizing the election process itself, given the timing. You know, as election season obviously comes closer and closer. How would you weigh in on that?
I don't think that really there is much that, has been affected by this judgment. The Electoral Commission has been preparing for the elections. You still have a lot of time before the elections take place. The elections are going to take place within 90 days after the date of the last elections, which means from the 10th of May to the 4th of August. And I think the Commission has got sufficient time. They've been preparing. The only aspect is in terms of candidates who will be the requirements for independent candidates. That is the only change that is actually there. And I don't think it is really going to be causing any sleepless nights for the Commission or even a major revamp of their system in order to accommodate the number of people who will be participating. The system should actually be able to accommodate all those who will be participating in the process. So I don't think there is much that has really been caused to disrupt the smooth functioning of or smooth delivery of the elections.
Okay, so Terry, as we conclude, perhaps you could speak to the processes. The processes from here on two, as the IEC prepares for the elections. What can we expect for as South Africans?
As indicated, now there are going to be independents who are going to be participating. We will be getting two national ballots, one which will contain the names of independents and those individuals who will be participating under the banner of a political party. They will be contesting those regional seats, the 200 regional seats, and there will be 200 seats that will be reserved for political parties. And therefore, when you come as an ordinary South African to the ballot booth, you'll be provided with two ballots, one which will contain the individuals who will bear probably the banner of a political party that is supporting them, and those who do not have a banner of political parties that we refer to as independents, and the one that contains only political parties.
Sarah, I know there's lots more to unpack, and one needs time to, in fact, study the judgments from here into. But just as we conclude, was this a win for South Africa's democracy at large?
It is a win for democracy in South Africa, because remember that from the time when the New Nation movement challenged the Electoral Act, and the Constitutional Court declared it invalid to the extent that it did not allow other South Africans to participate in election other than through membership of political party. That was significant. And for the first time, we're going to be seeing independents now participating in the process. Of course, there are still a few issues that still have got to be ironed out. The minister has now appointed a panel that will also be looking at the overhaul of the whole electoral system. And if it had not been because of this judgment, we would not be seeing the kind of the changes that we are seeing. And then that panel that the minister has now appointed will then look at the Electoral Act and make sure that independents going forward are part of the electoral landscape.
Terry Tselane, let's leave that conversation there for now. Thank you for your time with us on the SABC at this hour. Terry Tselane is Executive Chair of the Institute of Election Management Services in Africa, weighing in on the ConCourt having now decided that, in fact, dismissed the Independent Candidate Association's application to declare the Electoral Amendment Act unconstitutional. We also saw that the 15% threshold is also declared unconstitutional. An interim of 1,000 votes for independent candidates is signatures, in fact, will now be needed.